when I graduated, I thought to use my learning to advance the cause of people I identify with, the Aboriginal people, the Native people. I'm old-fashioned, the Indian people. It was fortunate that Columbus was sailing for India, and that thought he arrived, and that's how we became called Indians. If he'd been sailing for Turkey. In the course of my practice, I had my law office on the Enoch First Nation Reserve just outside of Edmonton, and I acted for First Nations, their organizations and individuals for a number of years in a wide variety of matters. And in the course of that, I started doing legal aid work. There was a court in a nearby community of Stony Plain, and I would get requests to take legal aid cases in that court for Native people. And I would check with the Crown to find out what they had in the way of a case, and almost invariably, my client would have made a full statement to the police. And I'd talk to my client and I'd say, did the police do anything to force you to make this statement? And they'd say no. And, well, did they say anything to you to entice you to make the statement? No. You made the statement voluntarily? Yeah. And with that, the Crown had their entire case in the statement. So I'd end up negotiating with the Crown on what was an appropriate plea and speaking the sentence. And I rarely had any trials. And it became very discouraging because all I was doing was pleading my clients guilty and speaking the sentence. And I had good results in terms of speaking the sentence, but it was very discouraging to me. I felt that I should be sort of fighting for their rights, and but I couldn't get over this, over the facts of the cases where these statements were made by my clients. And it became so discouraging that finally I stopped taking legal aid cases and started doing my practice shift between the various sectors of law I was involved in. And I thought to myself, perhaps I should be conducting seminars and explaining to people about their rights, that they don't have to make a statement to the police unless it's voluntary, that if they're being arrested, they have the right to consult with a lawyer and get the advice of a lawyer, that they don't have to say anything when the matter goes to court. The Crown is obligated to prove the case against them beyond a reasonable doubt. And I thought about that, but it didn't, there was something about that that didn't quite satisfy me. And I didn't see myself doing that. I didn't feel any sort of passion to sort of embark on that form of legal education. And I really didn't sort out what was going on until sometime later. The Indigenous Bar Association was asked to write a report on Aboriginal people and the Criminal Code by the Law Commission of Canada. The Minister of Justice had asked the Law Commission to look into that subject matter, and this is when all these inquiries, the Manitoba Justice Inquiry and other inquiries were going on, and this was the Minister's reference on the subject. And I ended up heading up a team of Aboriginal lawyers, Marianne Buller Bennett, now Judge Marianne Buller Bennett, Dennis Gladue, Eileen Paulus, who's now Eileen Sasakamus, and Albert Angus, who's still Albert Angus. Those of you who have met Albert Angus will understand the reference. And we all practiced in Indian country, so to speak, and we sort of put our heads together, our experiences together, our research. And when we came down to it, we found that the substantive offenses in the criminal code, there really wasn't much issue with them. An offense under the criminal code was an offense in Indian country to Indian people. If there was a severe assault, an aggravated assault where somebody is badly injured, Indian people would see that as an offense. There was a theft of some valuable property, that would be seen as an offense by Indian people. And the substantive offenses in the code with some sort of fine-tuning around the edges of some of them were essentially the two concepts, the criminal code and how Indian people perceived the proper order of things. It was basically the same. But the criminal code is more than a list of what are offenses to society. The criminal code also describes the procedure by which those offenses will be dealt with. It sets out the business about how a trial will be conducted, whether there's a preliminary inquiry, how appeals are made, how questions of bail are addressed. There's interwoven all through the criminal code is a procedural process. It's the process of criminal justice as opposed to the content or the substantive law of criminal justice. And that criminal code reflects the evolution of the criminal law in society, in Euro-Canadian society. And it's law that developed, you could probably go back quite a long ways, but Roman law, English law, Canadian law, it's law that developed through those periods, through those eras. And in early times, the power of the state, the power of the king, was so much greater than that of an individual that he could overwhelm the individual, and did so. For instance, if someone was thought to have done something wrong, a confession could be obtained by torture, or by saying, if you don't confess, your family will be imprisoned. And over the years, the courts and the lawmakers said, we can't rely on those kind of confessions because they could be given for reasons other than the truth. The confession can be made because of the pain instead of because it was true. The confession can be made to spare loved ones instead of because it was true. They said those kind of confessions are unreliable. So the law became that a statement to be accepted in court in a criminal trial must be made voluntarily and without any threats and without any promises. Similarly, it used to be that some of the trials that would proceed on a presumption that a person was guilty and that they'd have to prove they're innocent. And over the years that was changed. You're now innocent until proven guilty beyond a reasonable doubt. Another example is the open trials, that you don't have secret trials. You used to have what was known as Star Chamber, where the king, the sovereign, appointed his judges, and there would be secret trials of persons. And they would be found guilty. No one would ever know why, other than they've been found guilty. The judges didn't have the independence from the sovereign that was necessary for impartial adjudication. And then eventually the principle that judges are impartial, that they are not influenced by the government, became one of the principles that was accepted in the system. Now, all of these are in this evolution of the Canadian criminal law. And so you have somebody who's charged with an offense. They choose the right not to give a statement. They consult with their lawyer. They plead not guilty when it comes to trial. There's a week-long trial, and at the end of it, they may be found guilty. And if they're found guilty, there might be 15 minutes, in an exceptional case 30 minutes, where the sentencing will occur. The system functions like that. But among Native people, the group of us, the Native lawyers, when we looked at Native people, and we looked at how their justice system worked in traditional times, and we looked at their attitudes in today's times, we found that the thinking was different. Sometimes you see it in the interpretation. Frequently, when in northern Alberta, they'll have somebody who needs an interpreter, and they don't get trained interpreters. They get usually a native court worker, or they get somebody else to act as an interpreter. And the question will be, how do you plead, guilty or not guilty? And the interpreter will turn to the person charged and say in Cree, did you do it? What we found when we looked at the Aboriginal cultures, and this tended to be a common thread that seemed to run through the different societies and through our experiences, was that in the Aboriginal culture, to lie is a very serious thing. It was an oral culture. Memory and accuracy were very important, and reliability was very important. It was a very egalitarian society in the sense that there was very much of a, particularly in part of the world where I come from, around the Great Lakes, any person could persuade the others to take a course of action. And their ability to lead depended on their powers of persuasion. If they ever got a reputation for being a liar, their ability to persuade other people was destroyed. I've seen in Native community where someone committed what was a minor offense, not so minor back then, 20, 30 years ago, against the band. And that offense, it was a form of a fraud. That offense still affected the reputation of that person and the ability of that person to influence the community. So in Aboriginal society generally, there is an expectation that a person will acknowledge the truth. So if they commit an offense, they're expected to admit it, to acknowledge it. Now that's not the end of the matter. They have reason, they have an explanation of why it occurred. The person assaulted somebody. That person had said something that was taken as a very serious insult. There's some other explanation. But that first step, acknowledging what happened, was seen by the Aboriginal societies as the first step to behaving properly again. Leroy Littlebear at the University of Lethbridge would often say that the system, the justice system, undervalues the importance of a guilty plea from an Aboriginal person. That Aboriginal person acknowledging what they've done, that guilty plea, is taking the first step to behaving properly, and expects consideration in what to do about it. In the 15-minute sentencing process, you don't get much consideration. In the Aboriginal community, you know, that week-long trial we talked about, and then the 15, 30 minutes in sentencing, the Aboriginal community, it's 15 minutes for the who did it. It still takes a week. Because now the question is, what do you do about it? And the question is, how do you get society back to where it was, where people relate to each other in a peaceable way and everybody is able to go on advancing in their lives? And that takes time. There was an Ojibwe by the name of James Copaway. He became a Wesleyan minister, and in later years he promoted the formation of an Ojibwe nation around the Great Lakes. And he wrote a book. And in the book, there's one passage that struck me. I'll paraphrase because I don't recall it exactly. But he said, the Ojibwe is free to do whatever he wants to do, but he doesn't because he's constrained by his desire to have the goodwill of the Ojibwe nation. And James Copaway went on and said, of late, we've seen much of prisons and penitentiaries. He said that is a bad sign. He said, we are men to be reasoned with, not brutes to be whipped into duty. What happens in the traditional societies is that they have to find a way that people can again live together. There are some drastic solutions for severe cases. There's a sanctioning of the killing of the offender. There is the banishment of the offender, which in this climate, in the northern climate, can be akin to a death sentence. But more often than not, you're going to have that person around. So how do you get back to where it was before the offense? Now, when we were doing this report, this was a time in the sort of mid to late 80s. I think it actually started in around late 80s. One of the reports was locking up natives in Canada, which was Professor Jackson's report about the over-incarceration of Aboriginal people. Donald Marshall, the Royal Commission into the wrongful imprisonment of Donald Marshall Jr., Manitoba Justice Inquiry, the Justice Causey Task Force on the impact of the criminal justice on the Indian and Métis people of Alberta, the Royal Commission's Justice Inquiry, which they published under the title Bridging the Cultural Divide. All of these were going on during this period, all across the country. And many people were saying the system is not working. One of the things about it is that if the purpose of a justice system and if the purpose of incarceration is to maintain peace and order in the community, why is Aboriginal society not becoming more peaceful? And players in the system, whether they were prosecutors like Rupert Ross up in northwestern Ontario, or judges like Judge Golden in Georgian Bay, or Judge Barry Stewart up in the Yukon, police officers, corrections people, all began to look for different ways of doing things. Crown prosecutors, as I said, in Alberta it was the chief crown down in Lethbridge. But they all started looking at ways of doing things differently. And you began to get things like the Yukon sentencing circles occurring. You began to get the hollow water healing circles dealing with sexual assaults. And there is, in fact, a lot of flexibility in the justice system. And they began to use that flexibility and do things differently. Now, Tsuut'ina is, the Tsuut'ina are people that are Dene, they're in southern Alberta. They signed Treaty Number 7, 1877. They're Dene, as I said. They're related to the Beaver and the Chippewyans in the north, and to the Dog Rib as well, and they're related to the Navajo and the Apache in the south. In their stories of their history, they have their own story about the separation, their separation. It's depicted in a mural on one of the schools, where the people were crossing a frozen body of water, a large river or lake, a very large lake. And a child carried by his grandmother, saw something sticking up from the ice and wanted it. And the grandmother tried to chip the object free, and it turned out that that was the horn of an underwater serpent. And the serpent woke up and it roused itself, and in waking up, it began to break up the ice. And half the people had crossed and the other half hadn't yet. And that was the separation that occurred. The reserve they have is southwest, immediately southwest of the city of Calgary. There's a view of Calgary from the reserve. It is 18 miles by 6 miles. It extends westward into the foothills and the forested lands. It is. It also had a military base on it, including a residential quarters for the base. The reserve population, the last time there was any attempt to do a survey, was in around 1,300, with another 350 people living with those members. But there's even more living in an area called Black Bear Crossing, which was the residential quarters for the military on the reserve. The military is relocated to Edmonton. Those quarters were empty, and there was sort of a housing rush as people simply moved in. Other people would claim an apartment suite or a housing unit, and then turned around and started renting them out. So it became an instant small city on the reserve. The Tsuut'ina signed Treaty 7, and Treaty 7 has a clause in it that deals with the question of justice. The clause reads something like this. The Indians promise that they will obey the law and will keep order amongst themselves and between themselves and other tribes of Indians, and between themselves and others of Her Majesty's subjects. That clause has never been given any interpretation or legal effect. But a simple reading of the clause is that if they promise to obey the law, then the words that follow have to mean something else. And the words are that they will maintain peace and good order amongst themselves and between themselves and others, which suggests an active role for the Indians who signed the treaty in maintaining order in their communities. And that reflects what the historical reality was at the time. When Treaty 7 was signed, Canada had very little presence in Western Canada. And they relied on the tribes and the leadership of the tribes to maintain order in those communities. They had a small contingent of RCMP out in the West, but they were, the only way that that contingent could serve a useful role is if order was kept by the tribes and they dealt with the exceptions. Now, I'm going to take you back for a moment, aside from this historical outline, and just pose a fundamental statement, a question. Why have a justice system? And when you set aside all of the refinements and elaborations and history, the reason you have it is so people can live peaceful and secure lives, so that individuals can prosper and grow as human beings in their societies. For the Tsuut'ina, the time after treaty was a very difficult period. They had already experienced a number of very serious epidemics. When Treaty 7 was signed, within 3 years of the signing of the treaty, the buffalo were gone. The Tsuut'ina refused to settle on the Blackfoot Reserve at Gladue. The chief Bullhead said, if we Tsuut'ina settle with our friends the Blackfoot, over time our young people will marry Blackfoot young people, and eventually there will be no more Tsuut'ina. And he insisted that they have a separate reserve. And the government tried to force them to accept what the government was proposing by withholding supplies and rations to the Tsuut'ina after the disappearance of the buffalo. Bullhead would not give in, and eventually the government agreed, and the Tsuut'ina Reserve was established separate from the Blackfoot reserves. But on the reserves, there was no traditional way of life now. Alcohol was coming into the community. Some of the men worked in various occupations, but they were always marginalized in those activities. Now, when all of these justice reports came in, the Justice on Trial report, which was the Alberta Task Force report, also came out. And one of the questions that it was asked to look at was First Nations justice systems. And it recommended that First Nations justice systems be a matter of negotiation between First Nations governments and the provincial and federal governments. Now I'm going to take a step aside. This is a Gladue forum, and I'm just going to point out some things about Gladue to link with it. Section 718(2)E reads, what happened with the amendments to the criminal code in which 718(2)E came in was that the criminal code was amended to de-emphasize incarceration and essentially reformed the sentencing process by setting out guidelines for judges on sentencing, to introduce the notion of restoration into sentencing, and to address a number of other issues. Conditional sentences came in about that time, or a bit later, I think, and other options. But 18.2e is very unusual because it mentions Aboriginal people. It's the only place in the criminal code where a people is mentioned. And the section says all available sanctions other than imprisonment that are reasonable in circumstances should be considered for all offenders. All offenders. This section is not about Aboriginal people per se, it's for everyone. But even though the criminal code has been applied to everyone, Aboriginal people have been, in ever increasing numbers, the subject of the criminal code. So the words were added with particular attention to the circumstances of Aboriginal offenders. What does that mean? Well, if we look at the words of the Minister of Justice when the Parliament introduced the legislation, he said, "This bill creates an environment which encourages community sanctions and the rehabilitation of offenders," and then goes on. Community sanctions, that was something that wasn't in the criminal code. In R versus Gladue, Supreme Court of Canada looked at those words to determine what they meant. And the court said that this instructs the sentencing judge to pay particular attention to circumstances of Aboriginal offenders, and then goes on to explain what that means. The unique systemic or background factors may have brought the Aboriginal offender before the court, and the types of sentencing procedures and sanction which may be appropriate. And later on in their judgment, they say, "What is important to note that different conceptions of sentencing held by many Aboriginal people share a common underlying principle, that is the importance of community-based sanctions." Now, what I've underlined here is not all of what that section or Gladue, the R versus Gladue decision's about, but I'm showing you that the concept of community-based sanctions as a way of dealing with sentencing is a fundamental part of this provision, and is now a fundamental part of the criminal code. The Tsuut'ina had taken a number of initiatives on justice. They had established their own police service. They ran for quite a while in conjunction, in a sort of a joint venture type of arrangement with the RCMP. They now operate their own police service. I think there's an RCMP sergeant who still liaises with them, but other than that, it's their own police service. They also have a community corrections society, and that society has an agreement with Alberta, Solicitor General's office, to provide court worker services, to provide probation, to provide a crime prevention program, operate the fine option program, and provide, most recently, to provide victim services. Now, the Tsuut'ina proposal didn't come out of the Causey report, the Justice on Trial report. It came out of the Tsuut'ina's own approach to this question. What had happened was in the mid-'80s, a Tsuut'ina member was charged with driving on a banned road with no insurance. The case went to court, and eventually a court of appeal, and the court of appeal said, the provincial legislation requiring a person to have insurance on their motor vehicle applies to public roads. A road on a reserve that's a banned road may be open to all the members of the band, which may be a large number, but it's not a public road. Just as a field in a farm, or a road in a farm, may be open to all the members of the farm family, but it's not a public road. So the provincial legislation doesn't apply. About 10 years later, the elders at Tsuut'ina were becoming more and more concerned about the conduct of drivers on the reserve. This is essentially young people, but not only young people. They were near accidents, there were accidents, and they told Chief and Council, you have to do something about it. They said if a person doesn't have insurance, it's the person who's injured that suffers because there's no insurance. Council, Chief and Council looked at it. They had a traffic bylaw which wasn't being enforced. They revised that, and they started talking about how could they enforce it. And so they started thinking, well, we'll have a traffic court, and we'll enforce the bylaw. And then somebody said, well, why are we just talking about traffic? We've got break-and-enters, we've got fights, assaults, we've got mischief, we've got vandalism going on, we've got some serious offenses going on. Why are we just talking about a traffic court? And then somebody else said, why are we talking about doing it the white man's way? We should be drawing on our own traditions. The whole idea of this is to have a more peaceful community, and we should draw on our own traditions to achieve this. In 1997, the Tsuut'ina proposed a First Nations court. In 98, the province established a committee to look at it, and the committee came back and said there's no reason why it couldn't be done. This was the proposal. The Tsuut'ina said, we want a court, we want it now. We don't want to talk about sovereignty and take all the years and years and years to get there. We want something that we can do now. So we'll do it this way. We'll have a provincial court on our reserve, but everybody in that court will be Native. Moreover, we'll do things in the court in a way that's in keeping with our traditions, and we'll operate it in conjunction with a peacemaking program that draws from our traditions about how to resolve conflict in the community. The jurisdiction in the court, criminal. In Alberta, 95% of all criminal cases are dealt with in provincial court. Youth, family and child welfare, and civil. All matters arising on the reserve, regardless of who commits the offense, will come to this court. Matters could be waived in the same process that matters get waived between one provincial court or another. Peacemaking would involve diversion of the matters from the court to resolution in the community. The Tsuut'ina said to the province, if you agree, you start by appointing a Native judge. And the province advertised and interviewed, and on October 15th, I was sworn in publicly as a judge with the assignment of sitting in the Tsuut'ina court. The swearing-in ceremony was held at Tsuut'ina. But not only was I sworn in, 2 community peacemakers were sworn in at the same time to serve notice on the community that peacemaking was going to be going forward. And also, the Premier, the Chief, and a federal representative at the same time, after the swearing-in, signed an agreement to proceed with a comprehensive First Nations Justice and Peacemaker initiative. It took us another year to get everything worked out, to get the court started. The Tsuut'ina hired a peacemaker coordinator, a young man from their ranks, to fulfill that function. They recruited and advertised for candidates and trained the successful candidates to be court clerks. Those candidates were from the community. The Crown Prosecutor's office advertised and hired an Aboriginal prosecutor. We worked out the logistics of how to use the council chambers as the court facility. We worked out a protocol of how matters were to move between peacemaking, between the court and peacemaking, and back and forth, back again. We dealt with other things, more prosaic but equally important, how prisoners were to be handled and the like. The Tsuut'ina ran a course for the justice system. They had officials from the Alberta Department of Justice, the Alberta Solicitor General's, the Crown Prosecutor's Office, the police services, and the court administration on their culture and their community, because they wanted people in the system to understand their community. They hired a peacemaker coordinator, a young man by the name of Ellery Starlight. Comes from a very traditional family. He was training to be a forestry resource officer. They recruited him, and it was one of those recruitments that has the touch of magic to it. There are 2 court clerks who work half-time as court clerks. Sometimes they will sit in other courts in the province, as in Calgary or in Okotoks or surrounding communities as court clerks. They're fully trained, fully qualified as court clerks. One of them, the balance of the time, serves as a clerk in the peacemaker's office. Crown Prosecutor is a lady by the name of Lauren Whitney. Her father is a Cree from the Red Pheasant Reserve in Saskatchewan. She had articled with the Crown after law school, then went into private practice and had worked for a number of years for the Legal Aid Office as duty counsel in Calgary, and was recruited and hired as a Crown Prosecutor. Tsuut'ina does peacemaking, and they draw from the community for their peacemakers. The way they did this was they took a survey. They went to every household in the community and they said to the people there, who do you trust to be fair? And from that they got a list of names from the families of those households and from outside the families of those households. They screened the names. Somebody's on council, that's a political position. Somebody's got a job that keeps them too busy to be available to help. Somebody's got the wrong temperament, somebody's too young, somebody's got too much of a criminal record. They were left with 50 names after their screening. And they took the first third of that group and they put them through their own training for peacemaking. When a matter goes into peacemaking, the peacemaker coordinator who's in court and will do an assessment, decide whether it's accepted in the peacemaking or not. And then he'll assign a peacemaker. And he picks somebody who'll be seen as being fair to the offender and to the victim. So he doesn't pick someone who's maybe seen too close to one or the other. And he's got a pool of peacemakers to choose from. They asked the elders, what can we deal with in peacemaking? The elders said, they thought about it, and they came back, they said, no homicides, no sexual assaults. They thought about it, and they decided they would not take a matter into peacemaking if the victim did not want to participate. If the victim doesn't want to participate, they leave the matter in court. The offender must agree to participate. They don't have to agree, they can stay in court. They must cooperate with the process, and they must acknowledge responsibility. They don't have to enter a guilty plea, but they must acknowledge a responsibility. And the peacemaker considers other factors. They've done peacemaking for non-Tsuut'ina Native people. They've done peacemaking for non-natives who were charged and had offenses before the court. But the peacemaker coordinator makes an assessment on whether or not it's suitable. The peacemaking process, once a peacemaker is designated, that peacemaker will gather the offender, the victim, family members from both. If alcohol is involved, somebody from the treatment center. If the school's involved, somebody from the school. Anybody the peacemaker thinks is necessary for the peacemaking process. Always an elder. And the elder isn't the one running the process. The elder is the one, as they put it, to keep everybody in line. Offender, victim, peacemaker, or anybody else in the circle. They hold a circle. This is away from court. The matter, a person is charged, it comes into court, they take a look at it and decide whether or not, maybe the person says they want to go into peacemaking. We'll adjourn the matter. The peacemaker coordinator does an assessment. He contacts the victims, sees if they want to participate. And then he'll advise the court the next appearance whether or not it's accepted in the peacemaking. If it is, it goes for a long adjournment, typically 3 months. And then he designates a peacemaker, the process starts. They hold circles. They can have anywhere from 5 to 25 people in a circle. It can take anywhere from a couple hours to 2 days. It varies. First time around the circle, each person speaks. No interruptions. Everybody respects what they're saying. They start with either a traditional ceremony, or if people are not comfortable with that, a Christian prayer, or if they're not comfortable with that, they start with a simple statement: this is an important matter, this is a circle, we have to respect everybody in the circle, listen when other people are speaking, and when you speak with reason, not with emotion. Or I shouldn't say not with emotion, but not intemperately. The first time around the circle, what happened? Second time around the circle, how did it affect people? The victim is, it said, the victim is often the most effective person in the circle in bringing home to the offender the consequences and the harm that their actions have caused. Then a third time around the circle, what should be done? And that can take some time. And then finally, an agreement. And the offender signs an agreement, in effect, with the circle to do whatever the circle has decided. Maybe an apology. It may be restitution. It may be going into alcohol treatment. It may be counseling with an elder. It may be clearing 2 acres of land. Whatever the circle works out. And then the offender goes away and does that. When they're finished, they hold a 5th circle. And they take all the documentation they have in the peacemaker's office, except for a letter that's going to the Crown Prosecutor reporting on the outcome. And they have a little ceremony and they burn it. It's finished. As far as they're concerned, it's been done. The person's atoned for what they've done. The matter goes back to court. The peacemaker coordinator is a party in the court. I sit, it's a circle setting. I sit, clerks beside me, the Crown Prosecutor, defense counsel accused, probation and court worker, and the peacemaker across from the Crown Prosecutor. Peacemaker coordinator can speak on peacemaking matters on his own initiative. He doesn't need permission from anyone to speak to a matter. He gets up and says, peacemaking was successful. He provides the Crown with a letter, another for the court, and it lists in point form what was done. The Crown Prosecutor looks at the offense, the circumstances of the offense, looks at what was done, and if she decides that it's commensurate, it balances, she'll withdraw the charge. If it's something that is ongoing, for instance, if there's a requirement for psychological counseling and that's over a period of time, or if it's something they want to track, it's a domestic assault and they want to know if it should happen again in the future, the prosecutor may say to defense counsel, I'll withdraw the charge if your client's prepared to enter into a peace bond. And if they're willing, then the court's given the facts which form the basis for a peace bond, and usually there will be the recommendations out of peacemaking will go into the peace bond as conditions of the peace bond. One thing we use a lot in domestic assault matters, because alcohol is so frequently involved, is we make an order a condition that goes like this. I make an order that goes like this. You're not to, I ask the spouse if she's prepared to keep an alcohol-free home. If she says yes, then I ask the spouse, or the order that is placed on the husband is, you're not to possess or consume alcohol in the family home. If you consume alcohol, you're to stay away from the family home and your spouse until the effects have worn off. That way, if they slip and drink, they've got a way to avoid breaching the order. They can go, I usually ask them if they have somewhere else to stay, and they say, yes, I can stay at my brother's. And they can avoid breaching the order by going there. It also gives the spouse some control in the family home, because when the person starts drinking, she can say, get out of here or I'll call the police. Police have a reason to come then. The final circumstance is if the offense is a serious one and the Crown feels it must be reflected by a criminal conviction, then the Crown and defense will decide what's an appropriate subject matter or offense to plead to. There'll be a guilty plea, and what comes out of peacemaking, first of all, what the offender did in peacemaking gets credit. Crown and defense will speak to sentencing, frequently to probation or conditional sentence conditions. And what comes out of peacemaking gets also put before the court as recommendations on sentence. And then I pronounce sentence as I deem. There's a lot of checks and balances in this. The Crown's assessing when matters are going to peacemaking. Defense are similar, doing that in the context of looking after the interests of their client. The matter isn't automatically accepted into peacemaking. The peacemaker coordinator can say no. You know, they might decide the individual isn't sincere, or they might decide that doesn't make any sense. This was somebody who committed an offense in their community and has no connection with their community and doesn't make any sense. They'd say no. They won't take it. The victim has a say. If there's a victim, they might say, no, I want to leave it in court. The majority choose peacemaking. When matters return from peacemaking, the Crown does an assessment and chooses which way to go. Defense have their role, and then if there's a withdrawal of the charge or peace bond or sentencing, the court has its role. So there are a lot of checks and balances that operate. This is the Sootenay Court, and on its commencement, and I got the date wrong, it's October 6, 2000 when it started. We've been going since. It sits the first and third Fridays of each month. It is open court. The peacemaking that occurs away from the court. In that sense, it's an efficient process from the perspective of utilizing the court's time, the judge, the Crown prosecutor, the court clerks, defense counsel. We spend a relatively little amount of time with it. The community is spending a significant amount of time on it. They have a funding agreement with Department of Justice. Like any other justice initiative, they always run it as a pilot, not as a given part of the system. The court clerks they're the envy of the other clerks. All the other clerks have plain white tabs. The Tsuut'ina clerks have eagle feathers on their tabs. The medallion that I'm wearing is not mine, it's the court's. It's a Tsuut'ina medallion. It was part of the process they used to symbolize it's their court. We do some other things. We hold it, of course, in a circle setting. I start with a smudge, start court with a smudge, wear the medallion. All of those things were steps that were taken by the Tsuut'ina to have the community look at the court as their court. But the biggest single factor that makes the community look at it as their court is the fact that these are Native people. If I'm not there and somebody else is sitting, it still runs the same now. If the prosecutor's not there and another Crown prosecutor comes, still runs the same. If the peacemaker coordinator is away and somebody else is filling in for the peacemaker coordinator, it's still the same. It's a system. It is the people in it, two clerks beside me, Ellery Starlight, Marjorie Potterface on the far end from Tsuut'ina Stony Corrections. The lady in plaid jackets, the Crown Prosecutor, and the lady in the Métis sash is duty counsel, Sue Hendricks, and it's one of the elders, a couple of the elders from the community who are at the far end, Rodney Big Crow and Barbara Otter. So with that, that's the Tsuut'ina Court.